In Islamic law, marriage is recommended under normal circumstances, but may become obligatory or merely permitted depending upon the state of the individual. The general rule accepted by the Hanafee jurists and by many others is that marrying is a sunnah. The Hanafee jurist Zaahiree maintains that the Prophet, peace be upon him, mentioned the obligations that pertain to the pillars of religion and elaborated these obligations for us, but he did not mention Nikah or marriage as one of them. Further, some of the companions, God be pleased with them, did not marry, and Prophet, peace be upon him, did not disapprove their act. The companions, God be pleased with them, also elaborated the obligations when they spread out in the lands they had conquered, but did not mention Nikah as an obligation. He argues that just as unlawful sexual intercourse can be avoided through marriage, because of which some consider it an obligation, it can be avoided with fasting. The Zaahiree, even though their opinions are not binding on us as they do not belong to the Sunni schools, state that marriage is a universal obligation like fasting and prayer, as well as other universal obligations, so that one who relinquishes it, while having the ability to pay the dower and maintenance and to undertake intercourse, commits a sin. It is, however, necessary to distinguish two situations. First, marriage is a definitive obligation or farz for one who finds himself in a state of uncontrollable carnal desire. Thus, one who finds himself drawn to sexual intercourse finds it is difficult to exercise restraint in staying away from it when he has the ability to pay the dower and maintenance and he is not already married, commits a sin by not marrying. In the second case, where the person is not overwhelmed by desire, marriage is recommended. Shaafee said that marriage is permissible or is a matter of choice, like sale and purchase. Further, the contract of marriage is a means through which the satisfaction of desire is attained. Therefore, it is permissible, like buying a slave girl. In fact, it is just like eating and drinking in which a benefit is sought, but the seeking of this benefit is permissible, not prescribed. Shaafee concluded that devoted worship is better than marriage, for marriage is one category of the muamalat or transactions. This does not apply to the person who cannot control his carnal desire. Samarkandi says that in our view, that is, the Hanafee view, marrying along with the performance of definitive obligations and sunnah is better than not marrying for the performance of supererogatory prayers. This, he says, is the well-known issue of seclusion for worship. The rule then is that marriage is recommended and preferred with the status of a sunnah. And this rule leads to the conclusion that marrying is preferable to total occupation with supererogatory worship or nawafil. A tradition says, "Marriage is my sunnah. Thus, he who deviates from my sunnah does not belong to my people." As the sunnah is prior to nawafil, marriage comes before supererogatory worship.